and welcome to Bloomberg Quint. You're watching the fine print. Over the last few years, Section 56 of the income tax law has almost become synonymous with angel tax. Issuance of shares to an Indian resident at a price in excess of the fair market value of the shares attracts this provision. And the tax department has used it to the hilt to go after startups and question the value at which shares are issued by them to their investors. It's this approach that drew sharp criticism from tax practitioners and the judiciary at the recent conference of International Fiscal Association. Oh, and if you thought that the tax issues of startups are limited to Section 56, wait till you listen into this conversation that draws attention to the Section 79 problem, denial of benefit of carry forward losses if there's a change in shareholding of a company. Listen in.
Now the question that is before us is that the startup ecosystem is influenced by the prevalent tax regime. To discuss how the existing tax legislation impacts growth of startups, we have today a celebrated panel who've already been introduced to you. And we have some questions for the panel, which we will be raising to our speakers. I am skipping, to conserve time, the basic slides dealing with the background of these provisions. 56 to 7B is often described, you're all aware of the section, I'm not going into it in detail, is described as an angel tax. My question to Saurabh, how did this name come about as an angel tax?
It's probably one of the people who coined that term. Let me explain where it came about. So firstly, I think we're talking about international taxation. And I should mention that we have the unique distinction of being perhaps the only country in the world which taxes an investment as income. The challenge with startups is you don't have revenues, you don't have profits, it's just an idea. How do you value that idea? So when Sergey Brin was setting up Google, how would you value that idea? If you do fair market value, it would usually be zero. Book value usually would be negative because somebody spent money, there's no revenues. So eventually, where the angels come in and the angel tax names comes in, is what happens is you have a breed of people who've been successful entrepreneurs, business people, and after a while they decide to invest in other youngsters with good ideas and have a vicarious pleasure in other companies being created. Now, because they're knowledgeable about industry, about business, they can take a guess on what this idea might be worth. 99 times out of 100, they will be wrong. But one time, they will be right. So they take a risk. So when you get somebody with a great idea, you look at him and say, okay, what is a market for it? It will be a new idea. So you cannot look around and say, this person is making facial cream. Let me see what the market is for facial cream. Because there's nobody like it. So when Uber started out, nobody had done it before. So how would you find out what the market is? Skype, when it started, how would you determine what the market is? Because there was no precedence. So it's basically a bunch of things that you look at. So you will look at saying, okay, does it seem an interesting idea? We'll take a pick. Most often they can't give you a 5-year projection. They can't give you a 1-year projection. So even things like trying to do DCF is a waste of time. So the angel tax came in because when you invested as an angel investor in the company, there was a tax imposed on that investment. And that's how the angel tax name came about.
So as Saurabh mentioned, nowhere in the world do you need to tax investment. It's only in India that you tax the investment beyond a fair value. Now this is against the normal connotation of income. Income is something that is periodic, something that you earn by your efforts. And issuance of shares, whether at premium or at par, was hitherto held to be a capital receipt not liable to tax. Sir, I am not allowed to raise a question to the chairman, but I am digressing from the protocol. Do you think such a provision is constitutionally valid to tax the premium in excess of the fair value?
I think constitutional validity cannot be tested on this ground because it is within the powers of the state to levy income tax. And it is within the power of the state to define what is income. Now, it may be an absolutely obscure definition of income, but it is within the power of the state to do so.
Vivek, would you like to come in? That I'll just give you a case which I handled. Somebody signed, a production house signed a contract with a well-known reputed film director to produce 3 films. And they were celebrated investors like Anand Mahindra, Rakesh Jhunjhunwala, who valued what business the pictures would do, which were to be produced in the future. And ultimately, the taxman taxed the premium, saying that if you look at the DCF valuation, this is not what I seek to accept. And he taxed that. Do you think this is fair when otherwise it is established that the money is coming from reputed investors, their sources of funds are known, the genuineness of the transaction is established?
So actually, frankly, I have a slightly contrary view. I have some sympathy for the fact as to why the government needed to bring this law in force. Saurabh started off by saying that we are perhaps the only country in the world which has a provision like this. The answer to that question is also the fact that we are perhaps the only country in the world where a lot of laundering activity or a lot of transaction passes hands outside the books. And therefore, at the time that the government brought in this provision, I think it was a useful anti-abuse provision. However, the problem has been twofold. One, 2017 onwards, you now have a framework where malified transactions can be attacked under GAR. That framework is sweeping in its coverage, but also has your standard judicial tests of how it is to be applied. So if a GAR tax has to be applied, for example, you must go through a GAR panel headed by a retired High Court judge, etc. So what the government has, in fact, said in GAR is, this is my ability to tax something that is malified, but subject to regular checks that the legislature has introduced. The problem with all of what has happened in 56, 5627B, 56210, etc. is, it is so specific in its language and so sweeping in its coverage that the ability to read down, which Vasu was mentioning, which Justice Ahmed also alluded to briefly, is very limited. So if I'm standing in front of a court and the provision is very clear, the provision says value in excess of the DCF value, or value in excess of Rule 11 UA value. In the case of a listed company, value in excess of the listed company's share. I think it will be a very brave judge. Probably it will take Justice Ahmed's bench to be able to read down that provision. So that is the core problem with the way the section has been interpreted and will be interpreted judicially. So to me, the solution is, once you have GAR come into play, all these anti-abuse sections actually need not be in the Act itself. Whatever 5627B seeks to cover should actually be covered under Chapter 10, under Section 96, and that is where the government can achieve its objectives of capturing money laundering and yet not seek to tax genuine transactions, startups invested in by Anand Mahindra. And 5627B startups is not the only problem. Today, if I buy a company off the IBC in a court-administered NCLT process, and I buy it for a price which is lower than its then listed price, I can still be taxed under 5627B, 56210. So, to me now, the way forward is not your February 19 notification. Of course, it's welcome in the sense that it affords relief to one category of companies, startups that have approval from the government. But the way forward on this is, now that you have sections 96 to 98, you perhaps don't need these 56s.
I think the first thing that needs to really come forth is that this is not so much a debate on tax as it is a debate on the nature of commerce we want to nurture. We often, as tax professionals, get so clouded by the tax issue that we miss the core issue. What's the core issue here? There are 4 things that we can't lose sight of. If we as a nation want to foster entrepreneurship, because employment for our youth is a key issue, and even otherwise we want to create avenues where we generate wealth for young entrepreneurs, then that is part of what we are saying is a national commitment, a national policy. The second situation is, if your worry is the genuineness of the funds, then all you should be concerned with is the genuineness of the funds without getting into the domain of what is the appropriate value. Because the appropriate value in this business is an amalgam of many factors. You know, when I talk to my sons, they tell me, oh, does the business have a moat? Which really means, can anyone else replicate this business? When I talk to my sons, they will come and say, well, is this a business? What is the track record of the entrepreneur? How many exits has he had? Now, all of these are intangibles which a taxman may not be able to assimilate and respond to. But quite honestly, as we do in so many spheres of tax, why don't we leave the amount which is paid between the entrepreneurs rather than trying to second guess that? Because let's understand two vital facts. When that investment happens, it's a competitive process, even at an angel level. Nobody is giving their money away for free. And when that money is made, or invested, I want to ensure that I invest appropriately, because the reason I invest is to get a multiple on my exit. If all of these factors are true, then the only concern I ought to have as a regulator is the transaction genuine? Valuation then should be left to market forces. Everything that I want to work out to satisfy myself that the transaction is genuine is within the domain of what I must prescribe.
Just to take a point from what Mr. Shah said about genuineness of the transaction, I think we already have a provision, section 68. And if under 68, somebody is subjected to scrutiny and he's asked to prove the genuineness of the investor and the transaction and the creditworthiness of the investor, and if the transaction is kind of approved under section 68, is there a need to even get into the valuation under 56(2)(7)(b)? I think that's the point Mr. Shah said. I think that's a very valid point.
Our discussion with government, our position really was, if we have to find a solution around section 56, two elements must be out of that solution. A, valuation cannot be a subject. And B, it cannot be case by case. I mean, today we have 26,000 startups. 5 years we'll have 100,000. How many people would you hire in CBDT to do case by case? And secondly, if 10 VCs amongst us cannot agree what that valuation is, what will the poor tax guy do to do that valuation? And so once you take valuation away and you don't do case by case, that is when a solution came, which is the one that has come for startups.
I just want to add something here. See, one of the methods for arriving at the fair market value is the DCF method. Now, understanding from what you just said, hardly any investor in a startup really goes by the DCF method. So that DCF method option is really no option. And in which case, in every case of a genuine valuation of each share, if the DCF valuation is lower, it would be taxed. So ultimately, I think what we have to, as a community, what we have to attack is the fact that you can't just have the DCF method of valuation. In fact, what he just said was that you can't have any method of valuation at all, because that is basically a judgment call that a man makes when he puts his money on something.
And you are wrong 9 times out of 10.
He may be wrong, yes, he may be wrong. But that doesn't mean that, as he pointed out, as you pointed out, that it's not genuine. It's genuine. So a situation may arise where we may have to request that section 56(2)(7)(b) does not serve any purpose at all. Because after all, what are you taxing? You're taxing a capital receipt as income, which is a no-no in taxation law.
Yeah. So at least for startups, that solution, I mean, it
perhaps
doesn't cover the whole universe.
Just completing, perhaps section 68 by itself would be sufficient.
my question to you is, in case the DCF is to be applied, is it open to the Revenue Department to ask you to justify the DCF with reference to future results? By the time he makes the assessment, he has the actual results, and they may be at huge variance with the projections made. So, Ron would, Vivek, you can go. Yeah.
So actually, one of the interesting things is that in case of startups, what happens is that their business models change continuously. So the DCF projections, even if made just for legal form filling, at the time of an investment, are likely to be very different from when the actual tax assessment happens 2 years out. And the tax, by that time, the model itself may have flipped, and therefore one may see a very different enunciation of how the P&L, balance sheet, etc. looks like. So purely from a technical tax perspective, this exact issue, is it open to the tax office to question the projections prepared at the time of investment in the light of actual results as they played out? This question has engaged both the Jaipur and the Bangalore tribunals. In both those cases, the tribunal has held that so long as the projections can be justified at the time the investment was made, that is, they were made on the basis of consistent, non-malified, bona fide assumptions.
It is highly subjective.
No, it is subjective, but at least the tribunal has laid out this principle that so long as the assessee can demonstrate that it was done correctly, it was done bona fide, it is not open to the tax authorities to go behind it and then say, because projections did not play out, I'm going to now dock your valuation.
You come in at the right time when we read this question of whether these notifications help assuage and remedy the situation so far as section 56(2)(7)(b) is concerned.
First of all, a very, very good morning to everyone, and I apologize for the delay in joining this session. So, the fundamental question is whether these notifications help at all. I think the proof of whether the notification works or not works is in whether people are using that notification for taking exemptions or not. Now, the moment we have issued the notification and, we have created a system where they upload their self-declaration on the DPIIT website, it is taken automatically to CBDT, and CBDT then issues a mail stating that now you are exempted based on your self-declaration. Right? So this process is automated, it is done daily, and if I give you the figures as of yesterday, I get a daily update on this. So if I give you the figures, total number of entities that have applied, 514. Repeated cases, 98. Because there are certain cases, where they are not able to upload the forms. Sometimes that self-declaration form is not on the company letterhead. PAN number is not reconciled. There are some other issues where, the form is not complete, although it's a very simple thing. And out of so many cases, 374 intimations and exemptions have already been granted, right? There are 42 cases where they have not been granted for want of this kind of a shortcoming in their filing, right? This is done on a daily basis, right? And on every filing, whatever, if there is any shortcoming, DPIIT tells them, look, the filing that you have made, there is some shortcoming. CBDT doesn't get into a personal kind of a communication with startups, but we do that facilitation, and we say that now, this is the filing that you have made, and there is some shortcoming. It's a general kind of a mail which goes. So to have a relook at the filing that they have done. Every day, we are getting at least 10 to 15 applications for getting this exemption. This is the proof that, this notification finally is now working. And as Mr. Srivastav said, when we were trying to work out the solution for this issue, angel tax, we've been working for a long time on this, and this has been a pain point for a very long period. Last year also, when, scrutiny notices were issued, we had the same thing. We tried something, it did not work out. Again, this time, we thought, let's go to the fundamental issues. What are the issues? So one of the issues was the process of valuation. We said the process of valuation in a startup is fundamentally subjective in nature. It is actually a business deal between a startup company and an investor, and it cannot be subject to scrutiny by anyone else. It cannot be under scrutiny by CBDT or by even us, anyone. It is actually a business decision. He has a sense of what he's doing. He feels confident of doing it. He is a person confident of investing his money, so let's not question that. So we removed the valuation part out of this. Second thing we did was, there was an inter-ministerial board which was supposed to scrutinize each and every case and then grant exemptions. We said we are not getting into case-by-case basis. Let us formulate transparent criteria and give exemptions on the basis of those transparent criteria. And then the exemption is available to everyone. Let the tax, whenever, if the case is picked up for scrutiny, let them decide. And let them then get into the specific that particular case. So these are two fundamental things that we did. Once we were doing this, then, there were concerns raised by CBDT that, it could be a shell company. And Section 56 is actually an anti-abuse provision. It is not, the government is not trying to, generate revenue out of this provision. It is actually anti-abuse provision. So we spoke to CBDT to figure out what are their concerns. So they said, if it's a genuine startup, we are not bothered, let them continue with this. We are only bothered that this provision should not be abused for taking exemptions for money laundering. I said, okay, now how do you define, those companies which are doing money laundering? They said we have provision where if the company is doing investments in 1, 2, 3, 4, in land, in shares and in vehicles, in helicopters, and basically, those companies which are used for parking money and then their typical expenditure patterns. They said, okay, now this is acceptable to CBDT, this is acceptable to us, and this is acceptable to startups also. So, we have been engaging with startups and, everyone from the startup. And whenever we have meetings, very fortunately, we are actually fortunate, startup ecosystem responds very well to us. There is a vibrance. When we look out for suggestions, we are actually fortunate to have that. And this is how, this notification finally came into being. And we are actually very happy that it is actually now giving relief to startups.
I think Section 79, if people have studied in the context of startups, it talks of that all shareholders must remain the same in order that Section 79 does not trigger. So if you are requiring fresh funding, then there cannot be any change in shareholding in order that you don't fall foul of Section 79. And does anybody want to comment on that?
Yeah, I think that's one for the carry forward of losses, that the shareholders need to remain the same. I think there are some technical nuances around it with respect to, how you'll be able to meet that criteria, especially if you're a startup and you're looking at funding and you may get diluted to some extent. So using that section to your advantage, I think there could be some problematic areas there. When you look at the way that angel investments are being made, there would be quite a few small investors, and a lot of people have started putting small checks in startups. If there is a requirement that all of them need to be there, and if a P investor is coming in or a Class B investor is coming in, they will want to weed out the small investors. So it would be quite, probably it makes sense for the promoters to stay on board, but for everyone, especially people who put in really small checks to be on the board, that would, really then disqualify the startup for the carry forward, which probably is not the intention maybe.
In fact, 79, according to me, has outlived its utility. You see, merely because there is a change in shareholding, you deny the carry forward and set off the loss. That loss cannot be claimed by somebody else. But the section continues on the statute. We'll have to live with that.
All right. So Section 79 amendment is there on the agenda for us. We are taking it up this time.
Yeah. So Vasu, question to you. There have been many notifications issued in the context of startups. Which do you think will apply? And do you think, since the notification of February 19 has come in supersession of the earlier notifications, that should apply retrospectively to say that a startup qualifies?
Absolutely, yes. It is an emphatic yes. Yes. It is the notification is meant that way. It is worded that way. I'm absolutely clear about this. All the investments in qualified startups that have taken place before the notification has been issued are taken care of for exemptions.
No, even the category of startup that is enlarged, the definition has changed.
Absolutely.
whether that
So,
will-
as on 19th February onwards,
Right.
now all the startups which qualify as a startup, so 10-year.
No, for the past investment.
Yes, of course.
Yes.
That is exactly what I'm saying.
Okay.
I'm saying emphatically yes.
Why
That
don't
is
we
the
get-
intent.
Why don't we get CBDT to issue a circular
Absolutely,
to clarify
CBDT will
this?
do that.
Yes.
This is actually, unfortunately, CBDT is not represented here.
Right.
But this is the understanding with the CBDT that we have.
Okay.
And we actually had a debate on this. All those investments that have already taken place have to be given exemption and have to be given advantage of this.
This is certainly very welcome. Certainly very welcome.
Absolutely, yes. So we have fought for this, and we have CBDT on board on this issue.
For proceedings that have commenced prior to the date, the practical experience on the ground is that those proceedings are still continuing. It may need intervention at the CBDT level to set that right, even though that may be the basic understanding at the governmental level.
All right. So actually the CBDT has said that where final demand orders have been issued, in those cases this notification will not apply.
Yeah, and I think it's
Right.
also
So that is the exception, that is part of this notification.
I think
So
that will get to
except
court.
that, where final demand orders have not been issued, they can go into appeal and take advantage of this
But the
notification.
interesting part is 31st December 2018, tax officers took great pains to issue all the final demand notices.
Well,
so,
I think,
so in,
okay,
in a sense, therefore,
we could, again go to CBDT and talk to
Parul,
them.
yeah. Parul, you want to say something?
Yeah, no, I just wanted to say that, it specifically talks about that no coercive action shall be taken to recover the demands. It's not to really, quash the proceedings or anything. The issue would remain the same. And when we talk about, the valuation and substitution of DCF, NAV, those issues on the ground at the practical level, people will still have to go through all of those.
I think it is beyond my competence to answer this, so I would rather not comment.